Can a wife wriggle out from consent terms after receiving monetary benefits in divorce proceedings? The Bombay High Court, in its order dated September 11, 2023, directed a wife to keep her end of the deal under clauses of the consent terms for a divorce within 2 months and not withdraw from it. Justice Amit Borkar in his order stated, consent terms created mutual obligation on the parties involved. It is not permissible for a wife to wriggle out of consent terms after accepting benefits of it in divorce proceedings. So what was the matter all about? Parties got married in the year 2007 and have a minor child. In the year 2018, the husband filed for divorce at the Pune Family Court on grounds of cruelty by wife under Section 13(1)(a) of the Hindu Marriage Act. As per process, the divorce proceedings were then referred to a mediator. In September 2020, the couple finally agreed to some mutual settlement, and accordingly certain consent terms were drafted that created obligations on both parties. The husband was supposed to make financial and property transfers, while the wife was supposed to withdraw all the cases and allow access between the father and the child. Now, the advocate who represented the petitioner, husband, submitted that he had already complied with his obligations by paying around 12.5 lakh as permanent maintenance and also transferred the residential flat after paying off the loan amount on the same. Now, according to him, the obligations cast as per certain clauses of the consent terms had not been complied with by the respondent wife. On the other hand, the wife argued that the payment of maintenance was not fully complied with, as the husband had not yet transferred his public provident fund, that is the PPF account, in her name. Now, what was the choice left with the husband? The husband therefore filed 2 applications before the trial court seeking directions against the respondent wife and asking the trial court to direct her to comply with those consent terms, whereas the trial court kind of rejected his application, stating that he always had remedy available under the law. Subsequently, the husband approached the High Court to challenge this trial court order, which was passed in August 2022, rejecting his plea for directions to his estranged wife to honor those settlement terms. Now, what was the Bombay High Court order and what did they say? A single judge High Court bench of Justice Amit Borkar scrutinized the terms and was kind of satisfied they all were enforceable under the law. Disposing of the husband's petition, the High Court directed the wife to comply with these consent terms as agreed by her. The High Court also observed that the husband had very much performed his part of the consent terms by paying 12.5 lakh as permanent alimony to the wife and also transferred his residential flat in her name. The wife, on the other hand, had failed to comply with her terms, where she agreed to withdraw the domestic violence and cruelty cases against the husband and also allow child access. With regards to PPF, the High Court clearly stated that PPF needs to be transferred after the divorce decree is passed. The education cost. So now the wife was kind of worried, or she expressed her concern with regards to the non-compliance on sharing education costs for the child. To this, the court stated that she always had provision under the law if the husband failed to comply with it. Therefore, concluding the matter, the High Court ordered the respondent wife had accepted benefit arising out of consent terms. It was not permissible for the respondent wife to wriggle out of consent terms after accepting benefits from it. The respondent was directed to honor her part within 2 months of this order. The High Court also directed that if the respondent wife fails to perform her part on the consent terms within the stipulated time as above, the application filed before the trial court dated September 2021 shall be allowed in terms of prayer, basically, which was the consent terms that had been submitted in the trial court. Now, what is our take on this? These are classic examples of how domestic violence and cruelty laws have become mere tools in the hands of wife to enforce monetary settlements. Whether the divorce is initiated by a husband or the wife, it is only and only the husband who has to pay, even if the wife had been allegedly cruel to him. Voice for Men India is always of the view that any husband found guilty of being violent with his wife must face the law. Unfortunately, these settlements are aided by the system, leaving the men with no choice but to pay up. A counter-argument by women's rights activists is if the wife sends the husband to jail Who will provide for her and the children? Now, if this is the main contention, then what is the effectiveness of such a law? Sadly, these cases and settlements make us question every single domestic violence case today, whether the same is genuine or applied only to seal wife's financial security for the future. You can read the entire Bombay High Court order in the description link of this video. You can press that bell icon below and subscribe to Voice for Men India so that you can be updated with all the latest videos and orders that we publish. You can also follow us on our social media handles, that is X and Instagram @voiceformenind, and you can read many more articles on our website, that's www.voiceformenindia.com. That's it from me as of now. Thank you very much for watching. Namaste. Jai Hind.